Good morning, colleagues. Good morning, everyone. My name is Chimangazo Mbodi, Acting Deputy Director of Public Prosecution, attached to Gauteng Local Division, TPP in Johannesburg. Today is the 8th of May, 2024. We're having a maintenance webinar. Colleagues, I would like to welcome you to this webinar. But before I proceed, I just want to motivate you that the maintenance is the role of everyone. Let it be on us to say that the child outside, anyone, a child, must be maintained. So before we dive into our discussion, I would like to take a moment to introduce our esteemed guest, our speakers for today, who bring a wealth of experience and expertise in today's webinar. First of all, I'll start with closer to me, Mr. Ropi Sombulukwana. He's the Senior Maintenance Prosecutor for Gauteng Local Division, attached to Johannesburg Magistrate Court. He has got extensive experience with maintenance, with 14 years, and he gathered those experience from Mpumalanga, Limpopo, and now in Gauteng. So he'll be sharing with us the processes, the maintenance application, the processes, where to go, how to do that. And secondly, our next guest or speaker will be Advocate Hanezani Chusa. It's a maintenance prosecutor attached to the soccer unit, responsible for maintenance matters in Gauteng, and she is attached to the DPP Gauteng Local Division. She also has an extensive experience. This experience she gathered from 1997. Colleagues, our guest, you will take note that will be an expert. She's been there for long. So without even wasting time, please join us in welcoming our guest. And without further ado, I'll give Mr. Ropiwe Sompolukwane to start with the application process. Thank you, Mr. Ropiwe.
Thank you very much. Colleagues, thank you very much, people. As indicated, Mr. Sompolukwane, I'll be dealing or focusing on the requirements. What do you need to bring when you want to make application for maintenance? Application for maintenance are made at the magistrate office, where you are staying or where the children are staying. And you must have the following documents so that you may be assisted, so that they will be able to process your applications. Firstly, you must have at least 3 months bank statement of your account. Secondly, a recent list of your monthly expenses and supporting documents. Thirdly, you must have your ID copy certified, preferable, or passport, and you must have the copy of your marriage certificate if you are married, and you must have the proof of income, that will be your payslip or salary advice. And you must have any other information that will assist you relating to your income. When you arrive there, the maintenance clerk will help you to open the maintenance, to give you the application so that they will complete a form. We call it J141 form. Then it will be completed. And these documents that I have mentioned, they will be attached. Therefore, you will be given a date. They are going to issue the document, what we call a directive, to call the other party, which are reporting that he must be called or he must support you or the children. And they will give you the date in which they are going to call, also to inform the other party to come and appear on that particular day. When you return on that particular day, you will find your partner, you will meet with the maintenance officer on that particular day. And on that directive, the respondent, be the father of the children, be your husband, will be informed on the directive what document to bring on that particular day. Preferably his monthly expenses, salary advice. You will meet with the maintenance officer. They will look at the application. You will also be sent the copy of your application, how much you need. For instance, if you are applying, you are requesting 1,000 rand, you will be aware that you are requesting 1,000 rand for one child. So you will meet the maintenance officer, then there will be discussion, they will look whether he will be able to afford that particular amount. If he's not affording or there's no agreement, the matter will be postponed for formal inquiry. In other words, you have to go to court so that you may give evidence why you have to be given that 1,000 rand. And he has to give the evidence why he cannot afford to pay 1,000 rand. The court will make decision after hearing all the evidence. In the case of maybe you are coming to increase the maintenance order, they will assist you to fill J107 form. Then the same process will be followed. The directive will be issued. The other party will be called to come and appear. Therefore, it will be discussed before the maintenance officer. The maintenance officer will assist you to investigate your complaint. Therefore, if you don't reach agreement, therefore the matter will be postponed for formal inquiry. Then you need to go to court to give the evidence to convince the court why you must be given or why the maintenance amount should be increased. If there is a dispute of paternity, the respondent is saying, I'm not the father of these children. Therefore, there will be an issue of paternity test. In other words, they will advise you of the processes, then it will be arranged, the paternity test will be conducted. Therefore, after the results come back, then it will depend whether it's the father or it's not the father of the children. Then if it's not the father, the process will end there. But if the father, then the process will continue in a normal way. Maintenance, if you are applying, therefore you don't know where the father is working, we've got the assistants or what we call the maintenance investigators. They will assist you to locate where the father is or what that particular person is. That's what we call an ITC. It's a tool where the maintenance investigator use to locate where the father might be. He will investigate and try to find the father, then so that he may be called to come to court and you meet the father of your children, then the same process will be followed. So it is simple procedure to apply for maintenance, and after you meet, if you have reached the agreement, the maintenance order will be made. You will be given a copy. The respondent will be given a copy so that you may be aware what amount the respondent has to pay. That is a simple procedure. If there's any document which they require to assist you with the maintenance application, the maintenance clerk will inform you then they will assist you in applying with the maintenance. I think I've exhausted the requirements which is needed in the document. I've explained which is needed for you to apply for a maintenance order. That is a simple procedure. Thank you very much. I will wait for the questions if there's any.
Thank you, Mr. Sombulukwana. Without even wasting time, we'll then hand over to Advocate Chusa to go through what is maintenance.
Good morning, colleagues, and all the people who are joining us through all the social media platforms. My name is Hanetsani Chusa, as I introduced. My colleague has just mentioned the process of applying maintenance and what documents you require in court, and just a brief of what could happen in court. Now, from what he mentioned, I just want to add on what else can be claimed or what else can you apply for when you're applying for maintenance. Normally, people, when they talk of maintenance, they might be referring to things like only cash components. But in terms of the Maintenance Act, we have far more than just 100 Rand or 1,000 Rand. Maintenance Act provides for the application towards educational expenses, which that one is not limited to school fees. It could be school fees, school transport, school trips, uniforms, stationery, and the likes. Those things can be applied for under the same process which was mentioned, and the court will look into that one. The other stuff which you can apply for in a maintenance application is medical expenses. Medical expenses could be medical aid if the respondent is in a position of a medical aid or is a member of a medical aid. You can apply that the child be also added into that medical aid and the child will be covered. If the respondent does not have a medical aid, you can make application that at least that person should be ordered to pay for medical expenses whenever they are required. So in other words, if you don't have a medical aid and you have an order for payment of medical expenses, when you take the child to the doctor or to the clinic, if you are required to pay, then you have to submit the invoice to the respondent. The other stuff which can be claimed from the maintenance are household expenses. You will realize that sometimes you find that the applicant is a spouse or the applicant and the respondent were staying together. Now, when the respondent is no longer taking care of the household as required, nothing stops you as the applicant to go and say, my magistrate, I want this person to be ordered to continue to pay the bond or to continue to pay for water and lights as he or she was paying. So those are the other stuff which you can apply for. And then when you make your application, maybe the other person is who can you apply maintenance for? My colleagues mentioned about the father. So I want to add other people who have legal duty to maintain any other person. So legal duty is what the law will recognize. It's normally the relationship which the law will recognize to say, but these people have to maintain each other. Of course, a parent can apply maintenance from another parent who's not taking care of the children when they have children. So that is the maintenance between a parent and a child. As somebody who is staying with the child can apply for maintenance against the parents who are not taking care of that child. In other words, if I'm staying with my niece or my nephews, my sister's children, and my sister is not maintaining the kids, I have the right to go and apply for maintenance against her, and also even include the father if I know the father. Instead of me saying, no, Sissy, you are not taking care of your children, come and fetch them. The law protects the children, because remember, in terms of the Maintenance Act, everything is done with the interest of the children at heart. So when we talk about maintenance, basically we're saying when parents or people who've got responsibility to support the children are no longer able or do not want to do it anymore because of whatever reason, the law will say, I'm here now to protect the children. So the sister or the aunt or the grandmother or whoever the relative is who is taking care of the children can apply for maintenance against the parents of that children of those children. And then we have other people who can apply maintenance from one another. We have the spouses, married couples. If you are married, whether you are a man or you are a woman, and your spouse is not taking care of you, and according to you, this spouse can take care of you, then there's nothing which stops you to go to a maintenance court and make an application that the order be made against your spouse for payment of your maintenance or your day-to-day needs. People remember that you don't have to be divorced to apply for maintenance. We do have orders where parties are still living together in the same house. And because the other one is not taking responsibility, then the other person can come and apply for maintenance. Those are called spousal maintenances. Now we have maintenance which the child can apply on his or her own. If the child is over the age of 18 and the child is of the view that, you know what, I want to do it on my own, the child can go and apply for maintenance against the parents. Normally, the mother will apply, or the person who is staying with the child will apply, but there's nothing which stops the child to go and apply. Of course, the law does not encourage children to go and apply on their own unless circumstances are demanding that the child can go and apply, so the child can go and apply. Now, there is another set of people who can apply maintenance against his child. Those are grandparents and grandchildren. If the parents of the children are not in a position to can maintain their kids, the law says grandparents have the duty to assist those children. In other words, we've got a mother and a father, but they cannot afford to maintain their children. They have the right to go and apply against the grandparents of both, that's paternal and maternal grandparents, that they must come and assist in the maintenance of these children. Now, vice versa, because it's like that, then it will mean also the grandparents, when they are in a position that they cannot maintain themselves, they have a right to go and apply against their grandchildren to say, you know what, now you are now working, maybe I raised you or I didn't even raise you, that's not the requirement, the issue is the blood relation. So the grandparents and the grandchildren can maintain each other in terms of the law. And then the other set of people who we can maintain each other are brothers and sisters. Brothers and sisters have got a legal duty to maintain each other. So a sister can go and apply for maintenance against another sister or against another brother, depending on the circumstances. Remember, the hierarchy will be starting with the parents. Are the parents there? Can they afford to maintain their children? If the parents are not there, do we have any other parent? Maybe the grandchildren. Are they in a position to maintain these grandchildren? Or the grandparents, are they in a position to maintain the grandchildren? If they're not there, do we have sisters and brothers who are in a better position to maintain their siblings? Then the law can go to that extent. I think I've exhausted those people. Now, when you make your applications, I just want to point out few notes when people are making applications. And I'm saying this because or based on the number of complaints which we normally get from our applicants. You will find that, or maybe let me put it this way, other applicants are of the view that the court will force this person or make this person to pay maintenance dark or blue. Sometimes it may not work that way. If you have a partner who never worked in her life or his life, and then you have kids. After you have the kids, or then it happens that maybe your love relationship is not as blossom as it used to be. When you come to make application for maintenance, in that instance, you will just come and say, but I never worked in my life and I'm not even working now. You find that our applicants go to an extent of saying the law has failed them because they couldn't make this other person go and work. People, the law makes an order, or the courts will make an order where there are three things. There are three things which are required for the court to make an order. Number one, there must be a need to make a need for support. Number two, the person whom we are applying the support from should have the means to can provide the support which is required. Number three, that person should have a legal duty. So when we have one of these things, it is not there, it's very difficult for a court to make a court order. Let's say, for example, you have a child, as I just gave the previous one. There is a child, the child has got needs. This person who's supposed to support is the father, the legal duty is there. But this person does not have the means. That's where the process will stop. Because if there are no means, the court cannot make an order where there is nothing. But then, as I indicated above, you can go to grandparents. But as long as grandparents are in a position to maintain themselves, grandparents are supposed to assist. So if you feel that grandparents can, then you can approach the court and say, but let's try the grandparents. And then the court will look at whether the grandparents can maintain. Now, you might remember that I never mentioned about the uncles and the aunts relationship or legal duty in terms of maintenance. So you cannot come and apply for maintenance against the uncle of the child because the father of the child cannot pay. You cannot come and apply for maintenance against the aunt of the child because the mother of the child cannot pay. When I mentioned about the aunt who can apply for maintenance, the aunt is not applying for her own maintenance. She's applying for the maintenance of your children because she's the person who's taking care of the children. I think I've exhausted everything, and then that will be the end of my presentation. Thank you.
Thank you, police. The maintenance section, they were able to articulate very well what are the processes, who has the duty, and where to go when you need maintenance. So in brief, that is the process. So we want to invite you to ask questions so that we can be able to respond to those questions. Will be assisted here to check your questions. You can raise your hand.
Okay, we have Azwi.
Azwi, you are
Take
noted.
a question from Azwi. I only see one hand for now.
Okay, good morning, thank you. I just want to know if, like, the person that you want to apply or claim against for maintenance, say they cannot afford in terms of that they are not working, they don't have any income. But, for example, if they have received money that is not recorded, like there's some small business that they are participating in, but they don't get that money directly. Or maybe they get a cash out of big amount from the estate. And sometimes I've seen that when they get that kind of money, they would ask it to be deposited in another person's account. So what do you do? And maybe sometimes that person is living a luxurious life, but there are no records like in the bank or whatever.
Okay, it's noted. I'll take questions. I will note all the questions. Then our panel will respond to that. The second question.
Next, we have Sophie Modise.
Sophie Modise, you are noted. I'm
Good morning, colleagues. Mr. Lebe, wants to ask the question.
Good morning, colleagues and the panel. My name is Mr. Balibido, the maintenance investigator from Alexandra Military Court. In fact, here I just want to make an input or maybe add on what has just been said regarding the people who can apply for maintenance. What I have realized or discovered is that okay, anyone who's got interest, maybe even if that person is not related to the child, but he or she's got interest in that matter, like as a neighbor, she sees that he or she sees that okay, the children are suffering, they are not being taken care of. He or she can maybe come to court and make an application against the parent or parent of those children. I think yes, that's the thing I wanted to add. But the
Th-
panel.
Thank you, Mr. Libelo. It shows that you are working with that on a daily basis. Indeed, anyone with interest will welcome that comment. Then we'll go to another question.
We don't have to stand in this.
Okay, we don't have any raised hands. We'll respond to the first question that speaks to the means.
Okay, thank you. I think I'll respond to that one because I presented on the means. As I indicated, there are three things: legal duty, the need, and the means. Now, of course, that will be met. So when we come to proving the means, sometimes it is very difficult to prove that the person has the means to can cater for the application or for the maintenance which has been applied for. The colleague asked or gave an example of somebody who has got a very small business or someone who has inherited some money, but the money is not coming to that person. Remember, when we prove the means, we are going to look into that person's name or whatever is attached to that person's name. So we first, of course, go to the bank, and the bank does not have anything as indicated. And then we check with this office, and this person does not have any property in his name. And then we check with other businesses or with the CPIC. And then we find that there is no businesses registered under his name, but this person has got businesses on the side, which somebody, maybe it was registered under somebody else's name, and that person is receiving income. And that one maybe can be supported by the lifestyle which we can see this person is having. Now, it's going to be very difficult because the court will only decide that amount or that small business which has been registered is his business after evidence has been laid to court to say, no, this business A, though it's not in his name, it has been registered by somebody else's name, but it's actually his business. And for you to be able to do that, you will need to get this person's, the main member, the person registered on the business to come and tell the court. And I can tell you now, you are not going to get that person to come and testify. Because the minute when that thing is done, they planned it intentionally, so to say, I'm going to have this way so that at least I avoid paying maintenance. So that person will come and say, no, but I'm the one who, this business is mine. You can see from the registration of businesses, it's mine, the accounts are in my name. These guys have got nothing to do with my business. And even the business won't even pay anything to him. Now, the person now is got this luxurious lifestyle which you mentioned and which you can see, but we don't see where the money is coming from. It's going to be very difficult for the court to make an order to say, Mr. X, you are going to pay 1,000 rand. I don't care where the money is coming from. And I know it's a very frustrating process or answer which I give, but in reality, that is what's going to happen. Let's say then the person you say inherited some money. I just have another matter now, currently in one of the courts, where those allegations were made that the respondent is now inherited because he's the only son, I think, to his parents, and now one of the parents passed on. But then my question was, I need to get some more information that at least we can check how much is there and whatever, because according to us, we are dealing with the means. Where the means is coming from, it's not our problem. As long as we can attach something of it to this person, then we'll say you can afford to pay this amount based on what you have, and you are going to make an order. So if you say the person is inherited, it means now you are taking us to the estate office, where we need to go and check master's office and check whether the estate was registered and was this person one of the heirs on the estate or not. If he was not, or maybe when they say, I don't want to claim anything, and then whereas it was just an arrangement with the family members to say, I'm not going to be there. I don't want my name to appear there. I want you to get the money for me, and then you're going to give it to me in cash. It's going to be difficult for us to prove it. Because if we can't find anything attached to him, then we are going to be in a problem. Remember, in court, we work with evidence. Where there is no evidence, then there is no case. I think I answered it, and then you got the answers. Thank you.
Okay, thank you, colleagues. Is there any raise the hand?
As his hand was up.
Okay, as you still wanna come up, you want to ask another question?
Actually, answered, because, for example, if it's the payout from the divorce, so the state would know. So I think she has answered.
Okay, thank you, Aswi.
Okay.
Do you have any other question? Are you covered?
No, yes, I'm covered.
Thank you.
Okay.
Yes, we're going to another question.
All right. The next question is, what is the policy on maintenance in the case of lifelong disability?
Okay.
I believe lifelong disability is attached to the person in need. In other words, the question is not that clear, but let me try to put it in a way which, when I respond, you know what I'm responding to. When you're talking about policy on maintenance in the case of lifelong disability, I'm going to respond answering to a question which might say, what happens to a child who is disabled and has reached the age of majority, and this disability is lifelong, or is for life, for in case where somebody is blind and there's no chance of recovery and able to work, or where somebody is has got a disability or mental disability where there's no prospects of recovering, and that person will always be dependent. Remember, when I talk about maintenance, we might have mentioned the child. And the problem is, normally when we talk about the child, the definition of a child in terms of the law is anyone who is still under the age of majority. But in terms of our day-to-day talk, child is a child. I'm still a child to my parents, and it does not matter how old I am. So take it that when you say child, you meet somebody who can be. Remember another thing, before I go that one. So now, in the case of lifelong disability, that person will always be dependent on the parents, and it means that person will always have needs to be maintained by the parents, unless that person manages to work and get his or her own income based depending on the disability. Otherwise, maintenance will continue until that person is deceased, and for lifelong, if you can put that way. Maintenance will continue as long as that person is alive, because the disability is still there and the need is still there. So now, maybe let me just add a little bit about on the payment of the child who is over the age of majority. In terms of the law, the child can be maintained until the child is self-supporting, unless the order stipulates that this one will be paid until the age of majority, which we don't normally have those orders anymore. We used to have few of them the time when the child of the age of majority was still 21. Now it has been reduced to 18. So 18 years, an 18-year-old child is normally still at the high school. So that turning of 18 years will never affect the maintenance. So the order will continue until the child is self-supporting. Our orders which we make at the magistrate's court, they don't have the cutoff time. That J form which people normally sign does not have. So the maintenance continues until the child is self-supporting, even if the child is over the age of 18. As long as the child is still dependent on the parents, then the child can still go and show the dependency, and the parents will be ordered to continue maintaining the child. But based on that one thing which I just want to throw in is that you find an applicant of around 45 years old coming for the first time to apply for maintenance against his father. Then you ask him, where have you been all along? I remember in one letter you said, no, I've been looking after my parents, my father's cattles. Now my father is remarried, so I'm afraid that I may not have maintenance because it looks like those cattles are being slaughtered left, right, and center. So I want to protect myself. So now in those kind of things, you ask 45 years old coming to apply for maintenance. But anyway, as a maintenance officer, then I'll have to look at the application and see really, is there a need or is it a matter of coming to try and claim the benefit of the estate while the father is still alive or not. So, but anyway, there's no cut-off age of maintenance. Of course, the court may deal with the maintenance applicant who is a major, maybe a little bit different to a maintenance applicant who is still a minor and who is still schooling. Thank you.
Thank you. You want to add?
Yeah, I just want to add on the answer my colleague has given. The maintenance order doesn't stop automatically when the child reaches the age of 18. It doesn't stop, it continues. It only stops when the court cancels it. It must be clear, because some of the respondents, they will say, now the child is old, has reached the age of 18, I must stop paying maintenance. No, it continues until that particular child becomes self-supporting. Thank you very much.
Thank you. The following question. Can I refuse to pay maintenance if I am denied access to my child? We receive this kind of question a lot. Can we respond to that? Following that, it will be, can you note it? Can I stop paying maintenance if my child is legally adopted by my ex-new husband? So those two questions.
We also have Ndobe Tinyiko.
Okay, Tinyiko, can you ask your question?
Good morning, colleagues. Can you hear me?
Yes.
Yes. Just one question about future maintenance. I just want to understand if we can start the future maintenance when the respondent is no longer with. There's no court order. Somebody comes, they want to apply for maintenance, and upon investigation, the respondent is no longer working, but he was working, he just got retrenched. Yes, monies that they received from the mines or from the employer, provident fund. Can we start the process of future maintenance when there is no existing court order? Thank you.
Okay, thank you. So the first one, did you note?
Yes.
Okay, you can start, Mr. Sobulukwan.
Thank you very much. Question is, can I refuse to maintain the child if the access is denied? You cannot refuse to maintain the child because the access, you are not given the access to see the child or to be with the child. You can maintain the children, but you approach the children's court because that is where the access is dealt with. So that they will call the other parent why she is denying the access with you. They will make the arrangement. The child has to visit you maybe on weekends and whatsoever. That is dealt with the children's court. Together with the female advocate, they will assist there. But the maintenance is your duty to maintain. You cannot refuse because the mother maybe is refusing you to have the access to the child. You cannot refuse to maintain the child based on that.
Thank you. Let's go to adoptive.
Okay, thank you. With adoption, remember the requirements. Legal duty has to be there. So immediately when there's legal adoption says you are taking the responsibilities and the rights of the biological parent. For you as an adoptive parent, you are taking the rights and the responsibilities of a legal parent or of a biological parent, I'm sorry. So now, immediately when you do that, you are no longer required to maintain that child. There is no court which is going to make an order against you when you can prove that there is another parent who has taken my rights and responsibilities. The adoptive parent is supposed to be the one taking over those rights and responsibilities. But just to add up a little bit, in practice, we get parents or children who were adopted while they were still young, and now they've grown up. They said, no, but I need my relationship with my biological parent. And then they go back. I mean, that is their choice. I don't think anybody can stop them. And then you find that the biological parent is now even maintaining the child. So it means this child is going to benefit twice. But that child cannot go and claim maintenance from the biological parent, whereas that child has been adopted. Thank you.
Thank you. Let's go to future maintenance, the issue of the pensions. Can you attach the pension fund or provident fund?
With future maintenance colleagues and members of the public, future maintenance is a process, or it's a new thing which came into law through case law. The Maintenance Act does not talk about future maintenance, but through practice, when things are happening, then it was developed by case law. So at the moment, with all the case laws which we have, there has been a existing maintenance court order before we can talk about future maintenance. And unfortunately, we have never had, I'm not aware of any case where there was no existing maintenance court order, and now we talk about, and which then dealt with future maintenance. But in practice at the magistrates court, what has been happening is that there are situations where when we are forced to still continue doing maintenance when the person is not employed, is no longer employed. This is what can happen. If the applicant comes in today and says, you know what, people, I never applied for maintenance, everything was fine, I was staying with this person, or this person has been maintaining, but for the past 2 or 3 months, everything has stopped. And then when I find out, I realize, no, this person is now leaving or has now resigned from his employment, and I don't see this person paying maintenance anymore. I need maintenance. What we normally do, we then proceed with the application, and then we freeze the pension funds, but not to take future maintenance. We freeze the pension funds because that's the only means which we have. Sometimes we find that we do struggle to get court orders because the listener will say, but there's nothing. Why am I freezing this person's money? Please just rush and try to do the maintenance processes as quick as you can before the money can get finished. Hopefully we may get some money somewhere. But let's say we are doing that one, we manage to get the court order to freeze the amount, or even if we don't manage to get the court order to freeze the amount, then we do the application. When we do the application, when we talk about the means of this person, we're going to look at that amount which we can see, which is there. The court will then grant the application based on the means which we have. Then because a person is now left, and then we, upon our investigations, we find that this person is maybe about 50 or close to 60 years, is not a professional, chances of this person getting a new employment are very, very slim. This person might be talking about starting a business, which we don't even know whether the business is going to succeed or not. Then we can say, but we see the risk that this maintenance, even if it can pay, it might be for a few months. Why can't we then at least attach certain amount to cater as future maintenance for this child? And of course, based on the effects and the circumstances of each case, future maintenance court order can be granted under those circumstances. In other words, we immediately have a maintenance court order for a certain amount, let's say for argument's sake, 1,000 rand a month, and then looking at the age of the child, what is the child doing? Is the child closer to finishing school, or is the child still a minor? And then how much is available? That one we can guide. It can guide us to say, can we have maybe just 5 years of maintenance being paid as a lump sum into the court's account so that we can pay this 1,000 rand out of those funds? Because if we don't do that, we may, or we are risking that the money might be finished in the next few months and there will be no maintenance for the child. So those could be the circumstances where the future maintenance order can be made without an existing monthly maintenance court order. Thank you.
Okay, the next question will be, the panel has indicated that there was an input about neighbors who can approach the court for maintenance purposes. What measures are used to ensure that it's not abused by the public? Or please explain through an example that you have dealt with in court.
In my years of experience, I've never dealt with an application where the neighbor approached the court for maintenance. And I don't think legally that person will be able to fight and win that application if the respondent comes and says, no, but you are not taking care of the children. Because remember, you claim maintenance when you are the person taking care of these children. Taking care might be in a form of supporting them. Is the neighbor gonna come and say, no, but I buy them bread every now and then when they don't have food or they eat from my house, so I feel like I need to apply for maintenance? Maybe, because then that's the person taking care. Relationship does not matter, as I mentioned in the case of an aunt. Relationship between the child and the person taking care of the child does not matter. The issue is I'm taking care of this child and this child is costing me, and the parents who are legally liable to take care of the child are not doing that. Maybe that could be the reason to say I'm the one. They eat from my plate because I feel like I cannot deny them food, whereas they are in my house coming to play with my kids and I know that at home there is nobody. Maybe based on that one, the person can win. Otherwise, if just a neighbor who does not provide anything for these children, that person may not be able to claim maintenance. But as I said, I've never dealt with it that much. I know in terms of other abuses, the acts are very clear to say anyone who witness or who can do that these kids are being abused can go and make an application for the protection of the children. I hope I answered, unless there's something you want to add.
No.
Okay, thank you very much.
Colleagues, I don't see any raised hands, no questions. Can I take it that we are satisfied? We know where to go, how to apply, and we also know the processes of maintenance. Okay, there's no any hands. Colleagues, I want to highlight the following. As the office, Gauteng Local Division, DPP in Johannesburg, we've got an open policy on representations, complaints. I just want to indicate as to how do you go about those complaints that you might have. Let's say you are at a lower court. They've already indicated, the maintenance prosecutors before you, the panel, to say that the application of the maintenance starts at lower court. Let's say, for an example, Mr. Sonmulukwan is in Johannesburg. That's where your application will be. And the responsible people will be Department of Justice. If you have got a complaint in relation to the application processes, you are welcome to approach Department of Justice. It will start with the maintenance officers. Thereafter, if you are not satisfied at a lower court, NPA personnel that will receive your representation, you must start with the senior public prosecutor attached to that particular court. When you are not satisfied with that particular representation or complaint, you are welcome to go to the chief prosecutor attached to that specific court. Thereafter, when you have exhausted that process, you are welcome to approach our office. Our office in Johannesburg is DPP in Johannesburg, Director of Public Prosecution. We have got open policy. You can come directly to our office. You will hand in your representation. We will investigate and respond accordingly. That is the hierarchy of representation from this division. I think there is one question while I was explaining. Let me check.
Yes, we do have two questions from our external guests. One, Mr. Boho asked, what is the correct procedure to be followed by a maintenance officer for a garnishing order in order to avoid a situation where defendants will claim that they were not procedurally garnished? Then there's a second one again from Boho. What application should be brought forward after the complainant has exhausted the future maintenance monies? What application should be brought forward to court after the complainant has exhausted the future maintenance monies?
Thank you.
Okay, thank you. Maybe let me start with the second question for future maintenance, since it was the last one which we just dealt with. Future maintenance, as I said, is monies which will be placed in the court's account. Sometimes or previously we used to use guardians fund office. That money is a certain amount. I think I gave the example of 5 years maintenance when I was giving my example. Now let's say that money, the order which was made, it was for 5 years. Then 5 years passed and that money is finished. There is nothing which stops the applicant to come back to court to say now the money is finished. If actually the order will still be in existence, because in terms of future maintenance, the payments will be made according to that existing order which I told you about. So should that amount then be exhausted, then we have to call back the respondent and see if there are any means which this respondent has, which we can then continue satisfying the court order which is against him or her. Let me also give an example of a case where the respondent said, no, take 3 years maintenance. I will be fine maybe after 3 years or so. Then when the money is exhausted, then we have to go back to the respondent and check if he's got means to can pay maintenance. You will find that it happens by God's grace that this respondent managed to get another employment after losing the previous one. Then we're going to check on the current status. What is there now? Which means do we have now in order to pay maintenance? Then the order will continue as it is, or the order may be increased, or the order may be decreased to suit whatever the situation is at that moment. Thank you.
The first question.
I'll take the first question. What is the correct procedure for garnish order? We call it emoluments attachment in terms of Section 28 of the Maintenance Act. Normally, the complainant will come to court that I've got 3 months or 4 months without receiving maintenance money according to the maintenance order. The complainant will be required to fill in the J306 form, and she has to attach the affidavit indicating that the month, for example, of May, June, and July, I didn't receive the maintenance money, which is the total amount of 3,000 rand now. And she must also attach a bank statement to show that indeed she didn't receive the money from the respondent. Now the maintenance officer will go to the magistrate and make the application. Then normally the evidence will be presented or will be on the affidavit. The court will grant that emoluments attachment or garnish application. And on the other hand, sometimes the employer has to be given a notice. But if the court sees that the children will be prejudiced of giving the notice to the employer after hearing the evidence of the applicant, then they will grant the garnishing order or emoluments attachment order. Then it will be sent to the employer to start implementing that particular order. That is the correct procedure of applying the garnishing order. Thank you very much.
Okay. Can I just add on that one? I think the person who asked the question is saying, what if then the respondent says the procedure was not followed? It's coming to our attention that respondents think that they need to be called before the garnish order is made. In terms of the act, the section in which Mr. Sungulufani is mentioned, it does not require the respondent to be called to court. It's what we call an ex parte application. So as long as the documents are filed, the court is satisfied that there is a default on the part of the respondent, then the court will make an order. Of course, there are situations where the respondent will be called, and that does not mean that all respondents will be called. In another way, in other cases, is where you find that the court, when the magistrate looks at the application brought by the applicant, the court realizes that, no, I don't understand how these school fees amounts were calculated. I don't understand how she or he managed to come to these medical expenses. I think I need to listen to the respondent. That's when the court will say, please call both parties to come to court before the garnish order is granted. And that's when we have that process where both parties will be in court and the evidence will be laid formally so in a courtroom set up properly court. The applicant will make the application, respondent will respond to the application, and then the decision will be made. So basically, two processes can be applied. If you are not called, don't think that the process is wrong. No, it's not wrong. It's in terms of the law. Thank you.
Thank you, colleagues. The next question, can I claim maintenance for or from my spouse if they earn more than I do? Follow up to that, can I claim maintenance from my spouse for our children if they earn more than I do? What will the court consider in my application? And we also have a live question. To get it form, you want to follow up on your previous question on garnish?
Yes, yes, ma'am. Good morning, everyone. Okay, I'm making a follow-up on the question that I asked about the garnish order. Ms. Chusa has explained and the gentleman as well. But my question is, what happens in a situation where that specific application has been taken to court, but when it gets to court, the magistrate indicates that he or she is not a debt collector because there are areas the letter should not be referred to any people.
Wow. Okay.
For sexual area.
Okay. Yeah, it's a pity when we get our colleagues saying something like that. I mean, the way you put it, it shocks for the magistrate to say, I'm not a debt collector, and the matter should go to NPA. It means the magistrate is of the view that Section 26 does not exist, or the magistrate does not want that Section 26 in the Act, which unfortunately is there. It's a civil process of claiming maintenance. And when we go to NPA to claim maintenance, it's when we have realized that there is attachment of salary cannot be done because the person is not employed or formally employed. There are no properties which can be attached. And anyway, remember, with the attachment of properties is a lengthy, complicated civil process which it may require somebody to have an attorney to assist. So if there's nothing, okay, the other way, that process is when we attach what we call the debt, attachment of debt, which is so that the funds available somewhere, not from the employer or whatever, which can be attached to cater for the arrears. So when you have a magistrate who is making such kind of an order, because I think that is an order as well. Because remember, whatever the magistrate decides when the application is in front of him or her, it is a court order, it can be reviewed or it can be appealed against. So I will believe that the magistrate will write in the court file that I'm not going to deal with this matter because I'm not a debt collector. But I know normally you don't get those things in writing. Files will just be sent back. My advice is that we take that decision and then we bring the attention of a senior magistrate for that court to say, can you please intervene and just try to bring to the attention of the magistrate that there is Section 26 processes, which is in terms of the Act. And as the magistrate, she or he is bound to follow the law. The law is there. We are here applying the law in order to look at the interests or to save the interests of the children. So I think that decision, from my opinion, will be very, very wrong. Thank you.
Okay, thank you, Advocate Chusa. Ms. Paul, I'll suggest that you bring personally if it's something that happened, so that we can have a look at it and advise accordingly. I'll advise on that. So having said that, can we move to those two questions? Can I claim from my husband if he earns, or from my wife if he earns more than? Ms. Paul wants to follow up.
We have Sophie
Okay.
Disanyan, so I think maybe we can take that question and then we'll answer all of the questions at once.
Okay, Sophie,
Good morning again.
good morning.
I have a question or rather a comment or a request. Ne? We have a few matters where they have went for Section 31. The matters will stay as long as 2 years on the road. It gets postponed sometimes until the applicant loses hope and abandons the matter. Some of the matter never gets finalized because prosecutors will throw the matters against each other, or at some point they say they don't see the file or the docket until the applicant decides, all right, let me abandon this, or there'll be lots of complaints regarding the matter. Nothing happens. The matter will be on the roll long. Can we request that maybe prosecutors be trained out to deal with maintenance matters, because it would appear that some of them doesn't even prioritize them maintenance.
Okay. So let's start. Is there any other question? Okay, 3 questions.
Okay, I'll start with the first one. Can I claim maintenance against my spouse if he or she is earning more than I do? The issue is not about earning more or less. The issue is about whether your spouse is fulfilling his legal duty to maintain children or not. Yes, you can if he's not maintaining or she's not maintaining. Whether she's earning less than you do or she's earning more, it doesn't matter. But the issue whether is that particular person or your partner is fulfilling his legal duty to maintain children, that is where the duty arises. You can, whether a person is earning more or is earning less than you do.
Okay, I think also, while covering the question, indicate, because we've already indicated to the people that you can claim if you don't have a means while you're still legally married, you can claim from your spouse. So let's respond on the spouse. Mr. Sumbulubani has already indicated on the children.
Okay, the spousal maintenance. Remember, it depends on the needs and the means. Yet from the question, it's like the people are married, but this lady, she's earning less than what the husband earns. So she wants to know if she can claim maintenance. The answer is yes. Because remember, in a married couple situation, you get married and then that person takes responsibility to maintain you from your parents. So even if you are employed, if you can go and show that I'm employed, I'm earning, for example, 10,000 rand, but my expenses are more. They are not 10,000 rand, they are 15,000 rand. And this part of money has been maintaining me. Now he does not want to maintain, or she doesn't want to maintain me anymore.
Colleagues, can I request that we mute our microphones? We're getting feedback. Thank you. And
Okay. Thank you very much. Let's remember to mute the mics. So you can apply for maintenance. As long as you can show that your needs are far more, are more than what your needs are. Your needs are more than your income. And this husband has been maintaining you. Then of course you can claim maintenance. There is nothing wrong with that one. Remember, another thing which I can add is that when you claim maintenance as a married spouse, the duty for you to be maintained ends at divorce. So when you get divorced, if you ever reach this the time of divorce, then you need to make sure that the judge makes an order that maintenance be continued as it is, or for a lesser amount or for a higher amount, because immediately if you get divorced and you don't have that court order, then your maintenance will stop, because that's where your rights and duties ends when you get divorced. Thank you very much. Then, the last question. Section 31 matter, which is on the roll for more than 2 years. I'm not going to say that that does not happen. Unfortunately, or fortunately so, I'm seeing that, which I'm happy about, that court managers are on the platform, listening to this webinar, because maintenance affects them. And it's a good thing that you join and then you can ask questions and you can learn more. So since I've been in Gauteng here for a few years, I can tell you who is Ausofi Mutisanyane and who is Dikeledi Paul, they are court managers.
Okay.
In Gauteng. And the other, I don't know whether I must say West or good parties, the first they're asking about do exist, and I'm aware of them.
okay.
Okay, with the section 31 matters, let me speak to that. I just wanted to point to that. If maybe I answered like going towards the court manager, you must know it's because I have a background of the cases. The matters are not supposed to take 31 or 2 years on the court roll. What we are picking up, number one, you find that the application, the complaint went to section 31 because there are no other venues, or there's nothing we can do in terms of the civil attachment. As I said, now the matter is at the criminal court. From the experience I had, is that the matters are there and still prosecutors cannot prove that this person had the means to pay maintenance. Remember, we've been mentioning about the means. So in a criminal court, when I'm gonna go a little bit down, like deep into the law, because I think that will best respond to the question. When I'm a prosecutor and I'm faced with a criminal application or complaint, Section 31, and that Section 31 maybe starts from 2017, let's say from 2017, this person hasn't been paying maintenance up to now 2023. We're talking about 5-6 years of area maintenance. In terms of the law, I need to prove as a prosecutor beyond reasonable doubt that this accused of mine had the means to pay each and every maintenance payment when it was due. In simple terms, if the complaint starts from April 2017 and the maintenance payments are due on the 1st of each month, I need to show the court that on the 1st of April, this guy had the money to pay, but he chose not to pay maintenance and he did something else. On the 1st of May, same thing. On the 1st of June, I must go each and every single month for each and every year. And that process, you find that cases are going to the criminal court without those investigations being done. Then prosecutors on the court date, they get the file with the complaint of 5 years area maintenance, but there's no proof of means from those 5 years. It's going to be very difficult for the prosecutor to put the matter on the road. Chances are that if the prosecutor just put the matter on, proceed with the inquiry or with the trial, then the case is going to fail. And if the case is going to fail and this person is found not guilty, arrears are going to be written off, if I can put it that way. So now you find that along the process, when that matters on the road, remember our aim is to get maintenance for this child. Then I can see that it's possible that the respondent or the accused may pay something. I will try to say, okay, let me postpone for payment. I'm giving you 2 months to make a payment. And then he comes back, he didn't get the money he was expecting, payment is not made. And then hoping that maybe the parties can reach a settlement under mediation. Sometimes the cases are referred for mediation, they go there, they mediate, and still after mediation, they still come back because the money is not paid. That is still continuing as a criminal process. So there are so many reasons why the matters are not going to court. If I can now address the issue of training. Prosecutors are being trained. When prosecutors are still at their aspirant program, attending the aspirant program, we do provide maintenance training. And that's when we tell them that you will find a maintenance file one day, and please know that it is still your responsibility to do the maintenance case. Of course, you may find one or two who say, no, but I've never attended the maintenance training. But we provide trainings. Every single year, we have a training which is scheduled for 3 days, which is there every single year for all the provinces. So people are invited to attend the training. So trainings are being provided. And then another thing on the last note is that if there is anyone who needs a training, might be they are listening or maybe they are not, or as court managers, please advise them. I'm available to provide training whenever is available, whenever is needed. If I can just mention on Ms. Mutisanyani's case, in one case, I think 2 weeks ago, I had to call the prosecutor on the court date because he was on leave and say, you know what, let's go through the evidence which you have. How can you present it? What are you going to present? And then I went through the evidence with him, and then we agreed that he needs to do some certain actions. So training is provided, colleagues training is provided, and training is there every single year. NPA SOCA is training people. SOCA stands for Sexual Offences and Community Affairs Unit, which got a mandate of ensuring that maintenance cases are being catered for or are being dealt with. Thank you very much.
Okay, colleagues, we are nearing the end, but I see also there's still a hand.
Isihlangu.
Please, Sihlangu, can you go ahead and ask your question?
Greetings, colleagues. I step from Western Area Magistrate Court Maintenance Section. I wanted to find out, we have matters this side
whereby there was a garnish order that has to be implemented. It was sent to the employer. But now the employer, they are not complying according to the order. What do we do in that instance? Number two, even if the other one is the order by default, we have sent it to the employer, but they are not complying. So we need an assistance on how should we handle those ones so that we can assist the complainant. Number two, uh, the applicants are foreigners. They have the passport, but they do not have the work permit. The kids have the birth certificate. Do we assist them by opening the file this side, or they have to have a permit for them to be assisted? I thank you.
Okay, thank you. Garnish.
Granting the default, okay. The garnish order, when the employer is not complying, in terms of the Maintenance Act, you can charge the employer. You issue the summonses, and then as long as you have the proper return of service, that the employer is aware of the court order. But through my experience, in many cases, you find that there could be a reason why the employer is not paying. And remember, when you did the application, it might have been done ex parte, so the employer was never given an opportunity to come and comment on the feasibility of the court order. So my advice would be practically so, that's not in terms of the law, practically so, try to give them a call. Ask them, you have a court order, why are you not paying? Based on the reasons which they're gonna give you, then you can decide whether to criminally prosecute them or to attach their property, because that is in terms of section 29, if I'm not mistaken, that employer, or if the notice which is sent to the employer says, if you don't comply with this court order, you are going to be liable. And there is a sentence also mentioned there. So they can be liable criminally and also civilly for not paying that maintenance court order. Thank you. Then there is an order by default application. I think Mr. Subulukwan want to take this one.
There is an order by default. Now the employer is not complying with the order by default. What I can advise is that write a letter to the employer to question why are you not implementing the order by default. Remember, the order by default is an order of court. The employer has to comply with that particular order. If still you don't find a joy, subpoena the employer. You will see some action very quick, because no employer will want to come to court and to testify why it's not implying. I think your case will be resolved very quick.
Okay. There was one last question about the foreign.
The last question quickly about the applicants who are foreigners who don't have the work permit, as she put it. Remember, we are always guided by the law. The law says you must be a resident of the country. You don't have to be a citizen of the country. As long as you are the resident of the country, you have the right to apply for maintenance in your court where you are staying. The only challenge which we had previously was when people do not have documentation which we can now capture in the system will be rejecting and stuff and like that. That one is another issue. But as long as a person is a resident of South Africa, that person has got the right to apply for maintenance. I think the Constitution says this country belongs to anyone who is a resident. So you cannot take them back because they don't have work permit. They don't have to be in South Africa working for them to be able to be served or to receive the benefits of our law. So, but when you're dealing with the documents which are required by the ICMS, that will be another thing, which I remember in other systems, we used to put a default ID or default date of birth so that it can accept those people. But I'm not sure currently what is happening with the system. But yes, you can, if you are not sure about the capturing thereof, the court manager or the maintenance clerk can assist you to tell you that this is what it requires and this person does not have. Then you check how can we assist that person if it's possible. But otherwise, work permit is not a requirement. Thank you.
Thank you, colleagues. Thank you to the public at large as we are wrapping up today's webinar. Remember that the knowledge that you gain today is not only a theory, it's practical. You can take it to your own individual process and go and apply the knowledge that you have gained. Thank you for your participation as guests. We'll welcome any complaints, any representation as well that you'll be bringing, as I indicated just now, to say the hierarchy of complaining, it goes as follows. Thank you, everyone. That brings us to the end of our webinar. We are grateful for your participation. This webinar was not going to be successful if you did not tune in. We are grateful. Thank you.